Well, welcome everyone to Planning Commission and a joint training with City Council. Kind of segregated here, I don't know if I like this. Anyway, we're going to begin with an invocation by Commission Member Nalder, and then Commissioner Natalie Wilson will give us our pledge of allegiance.
Our dear Heavenly Father, we're grateful for this opportunity we have to come to this Planning Commission meeting and City Council meeting. We ask that by Spirit be here. We ask that our minds will be open to this presentation and bless and instruct that he'll be able to convey the thoughts of the President. Do this presentation the way we would like. We do love thee and give thanks to thee, and we say this in the name of Jesus Christ. Amen.
Everyone please rise. And repeat the pledge with me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, item 3, you're up.
Wow. Do you need me to use this microphone?
Probably, if you could.
Okay. Well, thank you for not gluing it down. That worked well.
Late for the assignments.
Well, thank you for letting me come, and thanks for the years we've associated without having any eye contact in any way whatsoever. We prepared this 3-hour presentation and have given it about 30 times. Sometimes I'm accompanied by other distinguished individuals. I don't mean other distinguished individuals, I mean other individuals who themselves are distinguished. And so we often have a little back and forth. So I'm feeling a little lonely tonight. So please, let's do some back and forth, because it'll make it more interesting. The main text we'll use is this book, which I assume each one of you has a copy of, although not here. And you don't need to have it. I'm just going to read a little bit out of it so you can kind of see what's involved. But the goal, and what I have done as the director of the Utah Land Use Institute, which is more or less my part-time day job, is to try to provide information to elected and appointed officials throughout the state. And that's been a lot of fun for me. I enjoyed it and learned a lot myself. The Office of the Property Rights Ombudsman has provided funding for this. Every time somebody gets a building permit, they pay a 1% surcharge, which goes to the Department of Commerce. And part of that's for training building inspectors, and part of it is for training land use decision makers and doing other things to help out the whole process of land use decision making. So thanks to them for the money. We also were supported by the Quinney Foundation. I always like to say thanks, so we don't appear completely ungrateful. We're co-sponsored by the League of Cities and Towns, the American Planning Association, the Real Property section of the Utah Bar, the Board of Realtors, the Home Builders, and we appreciate that support. That's helped us keep a good crowd out for these events. And it's not often that we do this specifically for one community, but I'm happy to do it. In particular, because I think West Haven has some unique challenges that really aren't the same as any other community in Weber County by any means. I'm not sure what other city in the state would really face some of the specific challenges you face. You know, for example, you have more open space in an area where there's a lot of pressure for growth, and you have other challenges that you probably can inform me about that I don't know, but it's a unique place. So we'll be quoting from this book, and if you didn't get a copy, then I'm happy to give you one for those who don't already have one. We also, by the way, can provide continuing education credit if you are a realtor, an appraiser, or a lawyer. So if that's helpful, talk to me. And I assume we'll take a break in the middle because I can't make it. And our optimal time is around 3 hours. I hope that works. Is that about what we expected? Sherry?
For about 2 hours.
For about 2? About 2?
Yes.
Okay. All right. There's no problem at all. I just have to shut up when it's time. Okay. So there was no zoning ordinance. There was no city. There were just people when the area was first settled. West Haven, of course, was just in the county for a long, long time before it incorporated. But as more and more people came, then they decided to organize the city. I think, as far as I remember, and I was kind of around, part of it was so that West Haven could be its own city and not just part of some other city. In fact, I heard, I don't know if this is true or not, that one of the suggestions for the name of the city would be not Roy. I just heard that somewhere. I shouldn't criticize anybody who's not here to defend themselves here. I don't know why this is going backwards all of a sudden. So we created a government, and we call it representative democracy. That is, we pick 7 people out of the thousands that live here, and they make the decisions for us. And when land use decisions come up, they always say yes, and everything goes forward just fine. Except sometimes all those people show up, and then sometimes the votes change. So what we want to talk about, basically, are the limits on local discretion. So we're taking a big picture view, and the idea is we want to look at what do we need to keep in mind as the boundaries. Where are the guardrails when we're trying to make local decisions? What have the courts said? And my job really is to just report to you what I think the courts have said. Understanding it, of course, if you can get 2 attorneys in the room, you can get 3 opinions out of them. But it's my hope is that it'll at least create a conversation we can have here for what time we have allowed. So the first limitations we have are the federal statutes and the Bill of Rights. By federal statutes, I mean the Americans with Disabilities Act and the Fair Housing Act and things like that. The Bill of Rights, we of course have the First Amendment for free speech. We have the Fifth Amendment for private property protection and other things like that. We have state statutes, and the way our system works, of course, the legislature is the source of the power the cities have. The city has no power that the legislature didn't give it. And generally, that power is broadly given. That's why we're called political subdivisions of the state. But occasionally, they'll step in and say, okay, we're going to narrow this discretion here, and we're going to tell you in this case or that case that we're not, that we're going to make certain discretion. We're going to limit the discretion to make some actions illegal. The most recent example of that would be the decision 1.5 years ago to prohibit design controls on new subdivisions. The state legislature just said, we're taking that off the table. And that's how it is, because we get our power from the state. Case law, the judges make decisions. And an example of case law that's had a dramatic effect is the way the Supreme Court has defended the people's right of referendum. And we have a referendum provision in our state constitution, which means the legislature can't touch it. So what we know about referendum, I don't mean can't touch it, but there are boundaries that the Supreme Court has set that say the legislature can only limit so much the ability of the people to take issues to referendum. But we also have case law that's created law that the legislature then enacted, like nonconforming uses. Those are from Old English common law. Those kinds of things were created by the courts in the first place. And then we have our local ordinances, which we have to follow, and we have codes and regulations, the fire code, the health code, the building code, and other things like that. So what we want to talk about generally, legislative acts and how they're interpreted by the courts, how much discretion we have. And the second will be administrative acts, what happens when we're doing making administrative decisions. And then we'll talk about appeals, maybe not get quite that far tonight, but I want to touch on it just briefly. We'll talk briefly about conditional uses and nonconformities because it'll help understand some of the case law stories I want to tell. When we do land use, there's different kind of folks that are involved. The citizen planners are you. You're citizens, you're not full-time planners, but you're the ones who make the decision. So we call you the citizen planners. Whether that's the planning commission making a recommendation to the city council, or the planning commission on an administrative basis actually just making a decision without the city council having to be involved. We've always, of course, had elected and appointed officials to manage land use. And we've also always had applicants and property owners who own the land that want permission to do things. But lately, we have neighbors and third parties. And so we have a real three-way discussion in ways we never had before. And I don't quite know how to explain this because often, back in the old days, and by that I mean when I was young, there wasn't an expectation that the neighbors would have input on all those land use decisions. It just kind of evolved over time. And part of it is our decision to send out notices and hold hearings, much of which is discretionary. The state code does not require many of the hearings that we hold. It's just a matter of our own choice. But that's created a sense of entitlement among the community that they're entitled to comment on land use applications. Actually, the most significant decision that's made when some use is going to be authorized is the building permit. That's when they actually build. But we don't expect neighbors to comment on that. We back that up. And what we really wish is that the input of the neighbors would come at the very beginning when we're doing our general plan and even when we're writing our ordinances, because later on, when we're just doing a subdivision approval, we just don't have the discretion we did originally. But that's kind of the tension that's going on. And in the middle of this, we have Sherry. So she just referees it all. She ends up being the coach, the facilitator, the explainer, and the initiator of the processes. So that's why you get the big bucks, Sherry. Thanks. Okay. So we're going to talk generally about a legislative act as opposed to an administrative act. So first of all, legislative acts are things like the general plan, to do an annexation, a zoning ordinance, zoning map. Those are legislative acts. Only the city council can do them. But in every one of those cases, they can't do it without the advice of the planning commission. So people have to go to the planning commission recommends an action to the legislative body, the city council then makes a decision. So in what context can those be challenged once we get to court? What the law says is you can only challenge a land use decision if it's arbitrary, capricious, or illegal. Now, illegal means it violates one of those statutes or ordinances or, constitutions that we mentioned earlier. And so we know what illegal means, but what about arbitrary and capricious? Well, it means different things. In the legislative arena, it means really rock, bed, solid, stupid. If it's not rock, bed, solid, stupid, then the city wins every time. Let me give you a story here. This is Draper. Actually, it's where it says Draper, that's Sandy. So across the center of this picture is 114th South, and north of it is Sandy, and south of it is Draper. And right in the center is this 10-acre bit you see there, a little undeveloped with a lot of brown space there. That's a location that Harmon's grocery store thinks would be a terrific place for a store. So they buy the property, and part of the reason is it's generally planned for commercial. The plan says we expect this to go commercial. And you can see on this zoning map that the other areas are already zoned residential. This is the plan though, it's not the zoning map. The zoning map still shows it as residential. So Harmons goes in and tears down the houses that are there and gets ready to build, comes into the planning commission and says, we'd like to build a grocery store. And they've got a site plan, they've got architectural drawings, they've got stormwater plan, they show how all the services are there available. They've done all the kinds of studies you'd need to meet every engineering and building requirement in the code. It's just, there's no question, it complies with every code and ordinance there is. Except the zoning map, because it's not zoned for commercial yet. And they've done a feasibility study, I would assume, kind of a fiscal analysis, that the great sucking sound you hear when they open their doors is going to be sales tax dollars from Sandy just flowing in to the Draper, the bank account. So the planning staff says, gee whiz, approve this thing. And the planning commission says, approve this, it's just terrific. But you see behind that lot, there are some pretty nice houses. This is what the front of a Harmons grocery store looks like. Pretty nice, huh? What does the back of a Harmons grocery store look like? Which one is going to face those neighbors? You're absolutely right. And these people who are peace-loving, very courteous, genteel people have a nuclear screaming hissy fit and come into the city council and say, don't do it. And the city council turns to the planning staff, and the planning staff may have said, it complies in every way. The general plan says you can anticipate this kind of growth. If you change the zone, it'll be consistent with the plan. So we're recommending you do it. And, you know, these neighbors knew they were building next to property that might be zoned commercial, so you know, it's not comfortable, but this is a great thing for the city. So Harmons might have even said, if you don't do it, we'll sue you. Well, on a split vote, the city council said, no, we're not going to do it. So Harmons sued him. What did the Court of Appeals do? Who do you think won this case? Yes?
I would say Draper, because your general plan is guiding and it gives some binding on it, but it's not the law yet, it's the zoning.
Exactly. So the general plan is a guideline only. And it's a legislative act. So basically what the Court of Appeals said is, well, let me read you what the Court of Appeals said. Harmons presented ample information to the City Council that would have justified Harmons' requested change in zoning. However, in attacking the city's actions, Harmons' burden was not to show the City Council had no reason to deny Harmons' application. Rather, the burden was on Harmons to show that the city's decision to preserve the status quo, the existing residential zone, could not promote the general welfare. And yeah, all the city would have to say is, look, the neighbors say it's not compatible. I mean, you go back to the very earliest zoning decisions made. The United States Supreme Court 96 years ago said they were going to allow zoning because cities should be able to put compatible uses next to other compatible uses. And that's what zoning started with. So then the court said this: it's a legislative body's prerogative to determine public policy, a judicial body's job to interpret the policy, and an administrative body's job to enforce it. Establishing zoning classification reflects a legislative policy decision with which courts will not interfere except in the most extreme cases. In fact, we have found no Utah case, nor a case from any other jurisdiction, in which a zoning classification was reversed on grounds it was arbitrary and capricious.
Can I ask you a question?
Sure.
So, in the past, we've been told that when people come in, they are vested.
Mm-hmm.
That they bid, and they spend a great deal of money to request a zoning change, which is apparently up to the city. So is there a time when businesses become vested because they've spent so much money trying to get into the city, or?
That question is a lead-in to my next story.
Oh, good, okay, thank you.
So, by the way, let me finish this one. This is the sign that went up when Harmons started to build their store. This is the store. So what happened? Harmons lost this case. Now, Harmons could have spent, it pains me to say this because I'm a lawyer. Instead of spending money on lawyers, they could have spent money on political campaigns. Or they could have gone to charm school. 2 years later, after another, I don't know whether the council changed, but the votes changed because Harmons came in with a better proposal. This building faces north, it doesn't face east. You can tell by your geography. And if you look at the building that is built along the property line to the west side of this property, there's a planted area between the fence line and the back of the building. The back of the building has no lights, has no doors, decorative brick wall. And the area between it is landscaped so nicely that if it were in Elko, it would be a national park. But it's a legislative decision. Harmons had to make it. They had to. I remember, I live in Plain City, and I remember a meeting I attended some years ago, I would say 18, and somebody wanted to build a business in Plain City, which doesn't sound that crazy, except we didn't have one. Not much. They wanted to put it at a convenience store. And the neighbors came out and said, no, 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 no. And one lady stood up and she said, how many people do I have to have here on my side tonight that this won't happen? And I thought, well, there's 7 on the council, 4. I mean, it didn't matter how many people were in the seats. The question is, what does it take to get 4 votes out of 7? On your point of view, that's it. And the convenience store went through, and now all those people are the same ones I see hot dogs there. It's particularly Saturday morning. It's a great place to meet. I'm just trying to be entertaining. I'm not trying to pick a fight, okay? So Harmons went to charm school and got this done. Now here's another one, and this goes right along with the question. What about vesting? Vesting is not a term that applies to legislative decisions. Nobody is vested. So here's the Sandy Hill Shopping Center, just a little farther north on 7th East. It's an antiquated shopping center. The Smith Investment owns it, and they're going to tear it down, and they're going to make a gazillion bucks when they do. Behind it is all this property, undeveloped, something like 15 acres. And Sandy City, I mean, they informed Smith Investment, but they didn't ask permission, downzoned this from commercial to R2 so they could build duplexes and nothing else. And they sued. This goes to the Court of Appeals, and an appraiser testifies, unopposed, uncontradicted evidence that Smith Investment took a $500,000 hit. Now, this was 25 years ago. Remember when you could buy a house for $500,000? I mean, this was a long time ago. And so Harmon sued and said, look at what you've done. It's a taking. You've damaged our property value. It's unconstitutional. So the Court of Appeals heard that and said, yeah, it looks like you lost a $500,000 of property value. It was worth $750,000. Now it's worth $250,000. So who wins this case? There's no vesting. This is what the court said. Some people win, some people lose. It's the price we pay to live in an ordered society. So these guys were not vested. And there's no vesting that occurs that mandates a legislative act. So the only way, in fact, even development agreements cannot be written to require some future legislative act by the city council. The development agreement must provide in its terms for the legislative discretion that needs to be exercised, and then when it's signed, that takes care of that. So and the reason in part is because what the court said in the Draper case, it's a different branch of government. We're the judges. We don't want to make legislative policy. We don't want to be the planning commission. So when it comes to planning and long-term decision-making and visioning, those are things that are legislative functions, not administrative functions, not judicial functions. So the judges also are saying, you're elected officials. We're not. And so we would be disinvesting the public of its ability to control its cities through the ballot box if we as judges stepped in and exercised our discretion on policy questions. So we're just not going to do it. Any question about that? Did that help? Okay. So when we write an ordinance that provides design standards, that's a legislative act, and those are going to be upheld unless they're really, really stupid or illegal by the interfering with someone else's rights. The amount of zoning, for example, the minimum lot size. When I took this picture, the minimum lot size here was 40 acres. So that development parcel is one building lot. So anyone buying this as development parcel needed to understand they're going to have to go to the Wasatch County Commission and get permission for greater density, or it ain't much more than a single dwelling lot. So this is all legislative discretion. So the Planning Commission recommends that the elected legislative body decides. Now, in a real ideal world, that's all the city council would do is make legislative decisions. But we have some give and take in our policy, and often the city council will say, well, we want to make some administrative decisions too. So like in Plain City, if you want a subdivision approval, it goes to the city council finally, and that's not inappropriate, but there's a legislative body doing an administrative act, and that's where the lines get a little blurry. So let's get off there. Before we leave legislative acts, though, I need to bring this one in. This triangular piece of property in the center of this picture is about 75 acres, and the City Council of Saratoga Springs zoned it for townhouses. You can see Utah Lake there on the right-hand side. The neighbors were not amused, and the Krejci family, as well as others, put it on the ballot box. They went through the arduous process of gathering signatures, giving the notice, having the signatures reviewed by the county clerk, who said, yes, you've got enough signatures, so this went to the ballot box. It also went to the Supreme Court because the city and the developer said citizens should not have the right of referendum to reverse a single lot rezone. And the Supreme Court said, yeah, they do. So the development was not built because the voters turned it down. Another more recent one was the Cottonwood Mall site in Holiday. Ivory Development and Woodbury Corporation had planned this gazillion-dollar project. The city of Holiday said, great. The land was already zoned mixed use, and that's what it is. But when the Supreme Court saw that it looked really like a zoning map, that this was such a huge project, they held that it was really, that approving this was quite legislative because such broad policy decisions were made in its approval about the future of the biggest parcel in the center of the community. So once again, the state Supreme Court protected the right of those citizens to take it to the ballot box and vote on a significant local issue. Any question about referendums and initiatives, things like that? Okay. All right, so now we're on the administrative side. Now, the world changes. We're doing a 180-degree switch here. And that can be difficult, particularly for a legislative person who holds legislative office, and often in the Planning Commission, because particularly in a community where they don't have this seasoned group as we have here, they get a little confused, and they think basically they can say no to administrative acts the same way you would say to a legislative act. In other words, you can oppose a legislative act just because it looks stupid, but you can't oppose an administrative act because it looks stupid. You have to look at the ordinance to see if the ordinance outlaws stupid. Because if the ordinance allows stupid, then stupid still passes. So those are very legal terms. I hope you don't mind me using lawyer talk there. So administrative acts are things like subdivisions, conditional uses, site plan approval, building permit, appeal authority, variances, that kind of stuff. A decision in the administrative arena will only be upheld if it's supported by substantial evidence in the record and it's consistent with the ordinances and laws, including vested rights, because there are vested rights in the administrative sector. So let's talk a bit about what that is. I forgot to mention this. If the land use, of course, we use the term land use authority, and you know what that means. It means that the planning commission and the city council together decided who would make the decisions in each land use, for each land use permit application. So who's going to decide subdivisions, and who's going to decide conditional uses, and who reviews the site plan, and who issues the building permit, that kind of stuff. Who does non-conforming uses. And when the decision is made that an administrative act is assigned to the legislative body, then we have to remember that that legislative body is acting in an administrative function, not a legislative function. So here's the vested right rule. And basically it is, if a person complies with the ordinances in place when they file the application and pay the fee, then they're entitled to approval. They're not entitled to approval before they pay the fee and file their application if the ordinances change while they're preparing the application. So there's just this drop dead date. So they come in and they talk and they raise the money and they get the loan and they say, okay, we're gonna do this, we're gonna build this subdivision. They're getting closer and closer to when they're filing and paying. If in this period the city changes the law, then all of a sudden they got to start over because they didn't file the application and pay the fee. Up until that time, there's nothing in the law they can count on. After that, then the law is locked. It's not to be changed, except for two exceptions. One of them is what we call the compelling countervailing public interest. This rarely happens, but for example, Mountain Green, Morgan County, somebody wakes up in the morning and the house is not comfortable. They're hearing things and seeing things that really raise alarm. And pretty soon after a few days, we find that even though this is not a mobile home, it's moving. And the house just basically moves down the mountain so that nothing's up there where it used to be except a mortgage. The mortgage stayed right where it was. And so let's say in this phenomenon, somebody comes in and says, okay, I want to build a house next door. The county can simply say, look, we've got a compelling countervailing public interest. We know you comply with the rules, but we've got a whole new ballgame going because the hillsides are not stable. So we need you to comply with an ordinance we don't even have in place yet, a geologic hazard ordinance to show that your ground is stable. Give us an engineering review showing that whatever you build there is not going to experience the problem your neighbor did. And then we're going to maybe even have it peer reviewed and see if we can resolve this overwhelming interest. Another compelling interest might be we just ran out of water. We don't have any to give. So we can't let you build a house that's going to have to connect to water. But again, these are rare and very harsh situations, and that's the only thing that can trump vesting, except for one other thing, and that is what we call a pending ordinance. So again, the developers out here getting the loan, buying the property, hopefully just optioning the property, not buying it. The worst, I was the ombudsman for the state for 10 years, and the worst situations I ever had were like the guy with a high income and a very good opinion of himself, who probably had some degree related to medicine, who would say, look, these subdividers are making money, maybe I can do this. So he buys some land and gets a 90-day loan, thinking he could just get all these approvals, he'd be digging dirt in 3 months. And it goes on, and everything's upside down, and he gets foreclosed on. And I mean, subdividers need to be aware of all this, and they generally are. So anyway, they come along, and the city all of a sudden figures out, they're counting on a density that we're not sure is going to work there. If the city proposes an ordinance and starts to review it, that would prohibit the application, that would prohibit the approval of the application, and that pending ordinance starts to be considered before the application is filed, then the city can apply that pending ordinance to the application for as long as 6 months. Does that make some sense? Okay. So here's the sequence. This is the date of filing. If a pending ordinance is placed on the agenda for a consideration, and I don't mean a glimmer in the planner's eye, I don't mean a bit of notes on a tissue. I mean, a specific proposal is on the agenda for consideration at the planning commission, say, before that application is filed and the fee is paid, then the city has the option of enforcing that pending ordinance against the application.
And after the fee is paid, then that, so say.
Doesn't matter. Some cities, and I think this might be incorrect, refuse to take the application. But I think the better practice is take the application, take the fee, and say, work with us as we craft this ordinance, because maybe it won't prohibit what you're doing. But the draft we have right now does prohibit it. And one's an easy, we're downzoning. Then if it is approved and we do it within 6 months, then we'll give you the money back, because, and some cities just don't want to give the money back and do that, and I don't have a strong opinion about that.
So, I mean, in the past, we've effected moratoriums on certain, but that would allow us to get that glimmer of a thought into a written plan. You're saying as soon as we have a proposed ordinance, then we have ground to say,
Yeah, it's a very informal moratorium. And it applies only to the provisions of this draft ordinance that's being considered. But you can also do a formal moratorium. It's called a temporary land use ordinance. And it's a little unusual in that the city council can enact a temporary land use ordinance on 24 hours notice without even the advice of the planning commission. But even if it's a temporary ordinance, it wouldn't apply to a development if the development is paid for and applied for before the temporary ordinance is enacted. But in the temporary ordinance situation, unlike the pending ordinance, you have to prove a compelling public interest. And so they're not really very effective. The pending ordinance typically is a better way to go. Yes?
So it seems to me what you're saying is, once you start that pending ordinance, it doesn't matter what it turns into in the end, it would still apply, right?
Right.
Because ordinances tend to just go through lots of changes as
Sure.
we go through.
But the critical wording and this is the language, to amend the municipal land use ordinance in a manner that would prohibit approval of the application as submitted. So in all honesty, if all of a sudden we decide, okay, we're not going to downzone it, but let's go ahead and put in some different criteria, then my guess is it's now time to go ahead and let his application proceed. Because in good faith, if we're not going to prohibit it, and we know we're not going to prohibit it, then we ought to allow it to go ahead. But this is optional. It's up to the city. It's up to the land use authority that's making the decision as to whether or not to play the pending ordinance card. Another question? Is that clear?
Can that be on a work agenda or a regular agenda?
I think it wouldn't matter which agenda it was on. And what the ordinance says in the manner provided by local ordinance and before the applicant submits the application. So the best practice would be to have in your ordinance a pending ordinance standard of how you do it. And that's the bulletproof way to do it. Otherwise, a developer could challenge it saying you don't have a local ordinance stating what's a pending ordinance. I mean, what's it pending? Is it pending? Is it not pending? I was a city attorney in a community in Cache County, and we got wind that an outfit was looking to build an adult business in our community, and Logan prohibited it, and we're next to Logan. So our feeling is that we have a lot of, young folks in the area, and they might enjoy this kind of activity. And the problem is we have to allow it because it's constitutionally protected under free speech. The Supreme Court of the United States says you can speak what you want to speak with your clothes on or without, It's up to you. So we have a right to regulate that, but we had no regulation. So with no regulation, they could have built it anywhere in any commercial zone. So we went to saying, now where could we find a really good ordinance? Provo. So we got Provo's ordinance and put it on the agenda and said, this is what we might do. And what we eventually did included some distance requirements from other adult businesses, schools, churches, that kind of stuff. So we were fine, Yes, they could build, but they couldn't build right next to Macy's on the main intersection. So that, again, that kind of pending ordinance helped us out. Another question? Happy to even have arguments if you want. I don't. Okay. Okay, so this is the administrative decision. The Land Use Authority decides whether legally and factually the application complies. If it does, approve the application. If it doesn't, deny the application. In any event, explain on the record how we got to that point. So just a bit about conditional use permits so the next story makes sense. So conditional uses under the ordinances are to be approved with reasonable conditions to address the reasonably anticipated adverse effects of the use. There are cases when a conditional use can be denied, but only with the finding on the record that the adverse conditions, the reasonably anticipated detrimental effect of the use can't be mitigated. Now, the standard in the state statute is not that it has to be eliminated. It just has to be mitigated. And so if a conditional use permit is going to be denied, then we have to outline on the record substantial evidence to prove that these negative aspects could not be mitigated in this location where they're proposing. Okay, I'll only tell you that 3 more times as we go through this story. So here's what we do when we go through a conditional use permit. 1, yes, sure.
Is that a state law or is that even broader than that?
It's state law. Yep. And so from state to state, it would vary. This is the Utah state law. And by the way, Utah is one of the few states, I would say there's only a handful in the whole nation that have a vested right doctrine. Most of them, you can change the rules after the applications are filed. That's just special to Utah. So when we're considering a conditional use, the question is, what are the reasonably anticipated detrimental effects? 2, can they be mitigated? 3, how should we mitigate them? And when people come and clamor against it, the neighbors, then what they should be doing is saying, here's a negative effect that can't be mitigated, or this is how we'd like you to mitigate this negative effect. That's the process. That's what it's about. Sure.
So if you feel like it could be mitigated, but then the person does whatever they want after the fact, then what's your avenue after that?
Well, you can enforce a conditional use application if you provided mitigation conditions and they weren't followed. But if you missed a beat and didn't put a condition to affect it and what the person's doing is not illegal, then we missed the opportunity to handle that one. Does that make some sense? So the person, and by the way, the only thing that matters is what's written in the minutes and on the approval. Some cities will do a written approval and list it all. And some cities will, in the minutes, put all the conditions, and the minutes become the record of the decision. Some cities will take the minutes and publish a notice of decision, so that's clear. And some cities will record that sucker on the title, so it's clear to any future, because the condition goes with, the use goes with the new owner if it sells. I mean, these are meant to be marketable. You can't build a motel with a conditional use and then try to sell it, and they say, well, you can't use it as a motel anymore. He's owned it for parks or something. I mean, the crazy thing is that all this was, the whole law was created from horror stories anyway. Everybody's trying to go along and do things normally, and then somebody does something that's irrational, and the legislature sometimes, with its legislative discretion, if it's reasonably debatable that it advances the public interest, the legislature can do it, because that's all they do is legislative decisions. But I digress. So this is Dannon Yogurt Company in West Jordan. They're in an industrial park that West Jordan wanted to really make upscale. And they love Dannon. Look at this thing. It's 5 acres of grass. Of course, it may not be this week. Grass is going the way of low mileage cars. But Dannon, let me show you how much Dannon and West Jordan get along. They named the road Dannon where it intersects with Prosperity. So where you have Dannon, you have Prosperity. And life is just wonderful for Dannon and for West Jordan. They're having a great time. Except right next door to their plant is this outdoor construction yard, which was built before they realized that it might not be attractive to their new industrial park concept. So as you look at Dannon's from the east side, you see this construction yard. And that would be bad enough. The problem is it's built, it's legal, nothing to do about it now. But there's all this land around the Dannon plant, and somebody comes in and wants to build another one of those construction yards. Ralph Wadsworth Construction. So Wadsworth Construction comes in, makes an application for a conditional use permit for outdoor construction yard. They hold a hearing. Dannon, this time it's not residential neighbors, it's commercial. It's industrial neighbors. And Dannon rallies the troops and comes in and says, hey, you approve that, our relationship is going to curdle. We are not going to let you allow another construction yard in this zone. So the Planning Commission says no, it's appealed to the City Council. The City Council says no, it goes to the Court of Appeals. And this is what the city said. This is the basis for the denial that was in the record. The city's made a significant investment in bringing Dannon to the area, and attributes which attracted Dannon to the area need to be maintained. Outdoor storage is detrimental to the area, making the area less attractive and injurious to the goals of the city. 2, outdoor storage may be considered to be a nuisance to neighboring property owners. 3, outdoor storage would encompass the majority of the parcel. The area and intensity of outdoor storage are much different than that of neighboring property owners. 4, outdoor storage is detrimental to the existing and future businesses in the area and is not harmonious with the goals of the city. Who wins this one? Does Wadsworth get to force this construction yard after the city council made those findings?
Was there any conditions?
Pardon?
Were there any conditions?
No, they just turned it down. Said no construction yard here. It's adverse to the city's goals. So here's the problem. If you read the ordinance for West Jordan, it reads like any other zoning ordinance I've ever seen. It starts out with all the city's goals. We want to have beautiful neighborhoods. We want to have families that are happy. We want rising property values. We want jobs. We want sunshine. We want rain in the rainy season. We want people to be safe on Halloween. And, it just goes on to state all these wonderful goals. And it says to meet these goals, we write this zoning ordinance. Well, the Court of Appeals looked at this and said, well, if it's adverse to the city's goals, why is it in the zoning ordinance? I mean, who wrote the zoning ordinance? When you had all this list of all these things you could have said yes and no to, why did you say yes? And then you're coming back to us and saying that outdoor storage is adverse to the city's goals when it's allowed in the ordinance as a conditional use. Similarly, it says outdoor storage may be considered to be a nuisance to neighboring property owners. Is that a finding? I mean, by the way, all of this may be true, but it has nothing to do with evidence. It's opinion. It's the broad-based policy considerations that we consider when we're enacting an ordinance. But when we're interpreting an ordinance, basically, we're applying the ordinance as it's written. We're stuck with it. Again, we had a 180-degree switch. So all the discretion to write the ordinance, but once the ordinance is written, follow it. Again, the court. In denying Wadsworth's application, the City Council relied on its finding the city's made significant investment. Outdoor storage is detrimental to the area and injurious to the goals of the city. However, the only evidence in the record supporting this finding are the concerns expressed by neighboring landowners, which is not evidence. Public clamor is not evidence. The record does not reveal whether the commission staff actually investigated the concerns raised at the hearing or why they concluded that outdoor storage would be adverse to the city's goals. So what the court is saying is, look, you need evidence, not conjecture, not what you are afraid might happen. And in this case, the city could have done some work. Wadsworth is a big company. They've got outdoor storage yards in other places in Salt Lake Valley. Go look at them. It says they're concerned about rodent traffic and dust. Well, get out your little rodent semaphores, and count those suckers and see if there's dust at those other yards. But all they said is, we're just afraid it might not be a good idea. Well, the time for good ideas is when the ordinance is written. It's a law, not an idea. Similarly, the sole evidence supporting the city council's determination that Wadsworth's outdoor storage may be considered a nuisance is the concern raised by neighboring property owners regarding increases in rodent traffic and dust. The ordinance specifically said the council could deny the application if it was deemed a nuisance. Did they deem it? They said it might be considered a nuisance to the neighbors. That's not a finding. That's not based on fact. What the court is saying, city, if you say you need to deem it, then deem it. Deem it. It's just too much speculation. Because once a person looking at the ordinance, they should know what they're entitled to. And if they bring in an application that's consistent with the ordinance and pay the fee and file the paperwork, then they get it when the ordinance provides for it. Any question? And this is a bit old, this case. It's 20 years old or so, but it was cited as recently as a few years ago by the Utah Supreme Court in a conditional use case.
So what happened?
So Wadsworth built this building. It's a lot nicer looking than the other one. And I took the picture before the landscaping grew. And they built a taller wall, and they're going to have an obscure fence across here, and it's going to be a whole lot different story because they attached reasonable conditions to make it more compatible with the others, which they certainly had the ability to do. They just couldn't deny it. Yes.
So when the courts hear this, do they just refer it back to the planning commission in the city to reconsider? Or, I mean, it sounds like Wadsworth was a good neighbor once it all came down. I mean,
Yeah.
how does that work out?
It's evolved over time. In this case, the Court of Appeals granted the conditional use permit. That wouldn't happen again today. But your question again is planted. Let me tell you another story. So, administrative land use decision will be upheld if it's supported by substantial evidence on the record and it's otherwise legal. So evidence is basically informed or credible, it's independent, and it's independent, it's credible, and I am going to go back a slide because I missed one. Relevant. So, but it has to be like you get in a courtroom. You can't go into a courtroom and accuse somebody of murder and one of the witnesses says, well, he's the kind of guy who'd do it, I'll tell you. I mean, that's what public clamor is like. I mean, that sounds laughable, but that's what public clamor is saying. And we must have evidence that it doesn't comply. So here's the answer to the question. This is McElhaney v. Moab. McElhaney wants to build a, dare I say it, short-term rental. We love short-term rentals? Yeah, okay. Well, Moab put short-term rentals allowed in the zone. The case is a little old because right now Moab is the last place in the world you're going to be open a short-term rental. But it was a conditional use as our story evolves. And you can see here this really long cul-de-sac. You know, see that kind of V-shaped thing lying on its side? So you have to go through the street that goes by all these other houses before you get to the last house, which is where McElhaney wants to put in an Airbnb. And although, you know, in Moab, one of the problems is that everyone who rents an Airbnb has a four-wheel drive ATV. And so they're going to be running up and down that street, back and forth, all day long, all night long, who knows. And so the Moab City Council basically says, no, we're not going to allow it. And the Court of Appeals said, this is the Supreme Court. They took this case, which usually would be heard by the Court of Appeals, and the Supreme Court said, you never explain why. There is no evidence in the record. All we have is the concerns of the neighbors. And so, in a decision that frustrated me, they remanded it back to the Planning Commission and the City Council and said, try it again. It's frustrated me because the poor property owner made the application, went through the City Council, went through the court system, all the way to the Supreme Court, and the Supreme Court says, go back and start over. The only good news is, the court did say, by the way, we really don't know where you'll find evidence to turn down a conditional use which you yourselves put in the ordinance as allowed in the zone. Because it appears to us you can mitigate those factors. And if you can mitigate them, you've got to approve it. But other than that, go ahead and take it. But this is the most recent case, we've cited it here, which basically says if you're going to make decisions, it's the council's responsibility to define the basis, not the district court. If a council is going to sit as an adjudicated body, that is doing administrative decisions, it must provide findings of fact capable of review on appeal.
Right.
Yes.
And that can't, those findings and things like that can't just be in the discussion, it has to be in the actual motion that the council or commission votes on, correct?
Well, the problem is the courts just really don't like these cases. And so they have they want it in the record. It must be, and they want to know clearly from the record what factors influence the council. It's the best practice to have written findings and conclusions, and then the motion could be based on the findings and conclusions in the record, plus this additional finding we're just making now, I move this. And that's the best practice. But when I do land use appeals, and I do that for 8 or 9 cities and a couple of counties, I find some staff reports so terrific. I do it for Salt Lake City, and often I'll be the land use authority. On non-conforming uses in Salt Lake City, I'm the flippin' land use authority when someone wants to change the use, because my job as the land use authority is to determine whether the new use and the old use are similar so that the non-conformity can continue. And so we'll hold extensive hearings and have a lot of chatter, but the staff has done such a great job of outlining things that if I don't hear things at the hearing that or the brief of the opponents, the applicant varies from the staff's recommendation of denial, then I'll include the staff in my decision as including it by reference, saying I agree with that. And that's where it is. The court just needs to go somewhere to find out specifically why the decision. It's kind of a long answer to a short question, isn't it? Yes.
Just a question on this. When, in a situation like this where it goes to court and then a court sends it back to the council or the planning commissioner, both, obviously that there's a period of time between the time it was denied by the city to the time that happens through the courts. And it's possible that the city has noticed a flaw in their ordinance and made changes to it. So when it comes back to the city, is it looked at through, are they required to go by the old ordinance when the application first came in maybe years ago? Or would the city be allowed to approve it based on the new ordinances?
It'd be the one that was vested.
Okay.
Yeah. The application's still going through the process, and it would still be the original vested rule, whatever it applied to it. Yes.
So as far as gathering evidence goes, is that something that should be done before the public hearing or before the conditional use comes to the meeting? Should that be done? Can that be tabled to get further evidence? Or?
It just has to be done before the decision's made. So in my case, you've put in your ordinance that I'm to hold a hearing within 15 days of receiving an application for an appeal. But it doesn't say I have to make a decision in that time. So, I certainly want to hold a hearing within the time. Pandemic fouled that up a little bit, but now we're a little more on track. And really want to know what are the questions, who's arguing what. And it's in our system, it's somewhat adversarial, although it doesn't have to be. It's not a courtroom. But if an issue comes up in the process, then we absolutely can pursue it and resolve it and take the time that's necessary. Because when we make our decision, it has to be supported by substantial evidence. And there have been cases, some here in West Haven, where somebody made an application that was, I'll use another legal term, loopy. That I asked the city attorney for the comment from the city attorney and got the comment, and the applicant said, okay, never mind, I mean, the process sometimes just works to resolve it without a decision being made. Other question or comment? Okay. So, my last administrative hearing, public clamor case, and then we'll talk about how to interpret the law. This is Davis County versus Clearfield. Can you imagine that? Can you imagine the county suing its own city? I mean, really, how does that happen? Here's a very nice old home on State Street. You probably haven't seen this in a while because they tore it down recently. And next to it is another older home. These are large homes. People with real money built these homes back in the day. And living on State Street wasn't even a problem back then. In fact, a lot of people went by and noticed how much money you had and how nice you had and, you know, what a nice home you built. But as our story unfolds, nobody wants to live in that house anymore, not on a 7-lane state highway. And so they're not ready to be torn down for some other use. And the county shows up and said, well, we could use them. We'll do that. In fact, we've got an idea we know everybody will love. We'll use them as alcohol treatment centers. And the neighbors in the back said, oh, goody, goody. That'll be right next door in case we get, have alcohol problems. It'll be really easy. The one thing the neighbors found most exciting was it's right across the street from Davis Junior High School, North Davis. So again, the neighbors came in and just really threw a fit and said this won't work. This goes to the Court of Appeals after the city of Clearfield turned the county's application down. This is what the court said. Nowhere in the transcripts is there believable information or evidence on which Clearfield could have rationally believed that the proposed mental health facility would pose any special threat to Clearfield City's legitimate interest. Does that mean there is no potential threat? No, it doesn't. It says nowhere in the transcripts is there credible evidence of that threat.
So they just didn't state it.
Well, they didn't prove it. In fact, look here, it says, with regard to concern over real estate values, no studies were made, no opinions were given by professional real estate appraisers, nor was any credible evidence of reduced property values produced at the hearing. So when we're doing an administrative action, our entire universe is within the four corners of that action. And you'll love this part, it said, the opposition did not have factual support in the vague reservations expressed by either the single-family owners or the commission themselves. So your own vague reservations are not evidence. The reasons did not justify denial of the permit, even though they would have been legally sufficient had the record demonstrated a factual basis for them. Now, I am not yet here talking about the Fair Housing Act and the Americans with Disabilities Act. I don't know how this case got under the radar, because a similar case in Duchesne County ended up in a multi-million-dollar judgment against the county for turning down a treatment center. But in this case, the court will use this to talk about public clamor. The consent of neighboring landowners may not be made a condition for the issuance or denial of a conditional use permit. The opposition of neighbors is not one of the considerations to be taken into account when determining whether to issue a permit. The local government must rely on facts and not emotions or local opinion to make a decision. So basically, the McElhaney case says you've got to lay on the record exactly what evidence you're relying on. And then the court and the state legislature have said, if you got evidence to support your decision, then all the ties go to you, If we just go through the process and have credible evidence. So let's go back to where we have a house that might be on soil that's geologically unstable, and somebody wants to build a house next door. Let's say we have a geologic report that says it'll be safe and 10 that'll say it won't. What do we have to do? Trick question. Decide. Because the rule is substantial evidence. It's not any other level of evidence. If you have one credible bit of evidence on your side, it doesn't matter how much evidence on the other side, the courts will say, then it's up to you local officials, you decide. Because you're the planners, we're not. So if I look at a meter of how evidence works, if I'm Perry Mason and somebody's trying to accuse my client of murder, then we're over here where it takes clear and convincing evidence, beyond a reasonable doubt. This is serious stuff. When we're in a civil case, then we need preponderance of the evidence to get our $1 million judgment against the joker who damaged us. When we're in the land use context, we're over here. It doesn't have to be a majority of the opinion, the evidence. It simply has to be evidence to support our decision. Because like a jury, you're the decision maker. You're the fact finder that gets to look at the facts, sort them out, and decide what's credible. Question about that? Okay.
So I do have a question.
Sure.
With this, because they lost the appeal, were they able to?
They did build the treatment centers.
Right, I grew up actually right around the corner from these treatment centers, so I remember this
Yeah,
vaguely, but it was a long time ago.
it was. The interesting thing was that they're sitting here talking about it, and they turned to the police chief and said, "Chief, these are hotbeds of crime, right?" And the chief said, "No, if they're managed well, there shouldn't be really any there."
I will say, we never had any issues.
Yeah.
We never had any issues with those treatments.
So a lot of it is just really an apprehension. And yes, it's an apprehension, but we know it'll go away if you don't let it build. And maybe it'll be okay, maybe it won't, but we know it'll be okay if you just don't let it be built. And that's a great conversation to have at the general plan stage. Not a very good one to have when the application's already filed. But you knew that already. That's why you guys get combat pay for.
Yeah.
Okay. So, an administrative land use decision will be upheld if it's supported by substantial evidence in the record and is otherwise legal. So, let's take a minute and talk about how to interpret an ordinance. A land use authority shall apply the plain language of land use regulations. If a land use regulation does not plainly restrict a land use application, the land use authority shall interpret and apply the land use regulation to favor the land use application. So again, we did a 180-degree switch. All the discretion on the city side to write the ordinance and say anything that isn't absolutely stone dead stupid. But once the ordinance is written, then the landowner is entitled to use put their land to whatever use they wish, so long as it doesn't clearly conflict with the plain language of the ordinance. The best evidence the ordinance's intent is the plain language of the ordinance itself. We presume the city council was deliberate in its choice of words and used each term advisedly in accordance with its ordinary meaning. Where an ordinance's language is unambiguous and provides a workable result, we need not resort to other interpretive tools and our analysis ends. So one thing the courts have not enjoyed is when someone tortures language to try to create an ambiguity or make it say something it doesn't clearly say. And this next case will kind of illustrate this. This is a nonconforming use, and so I need to touch briefly on that. A nonconforming use was legal when it was created. It was never illegal. Then the law changed, and it became legally nonconforming. It's still not illegal. It just doesn't conform to the ordinance because it did once, and now it doesn't. The third point is it can't be abandoned. If it's not done for a year, then all of a sudden that vested right lapses. So this is a story about a junkyard, and it's called Backyard Auto. And West Valley City said, well, not in our Backyard Auto. This guy had a junkyard use, auto salvage. And so they go to the Court of Appeals, and this is the property in red there. They go to the Court of Appeals, and I'll just try to do this in kind of a conversational style. The lawyers, of course, briefed it more formally. The court may have said, what are we doing here? And the applicant said, well, they're trying to shut down my auto yard. And the court might have turned to the city and say, what's going on? The city said, well, he's abandoned his use. He hasn't sold any old car parts for a year. So therefore, he can't have his junkyard use anymore. He's got to clear it up, get rid of all those cars that are on the lot. We can see there all those cars. It's ugly. Back to the property owner, well, what's your answer? And the property owner says, I'm still doing what the ordinance says I need to do to preserve a junkyard use. How so? Well, read the ordinance. The ordinance says junkyard use, to keep or store, sell, or disassemble cars. Court says, okay, property owner wins. Because the city used the word or instead of and in the ordinance. If the city had said to keep and store and disassemble and sell, then not doing any of those would eliminate the use. But the city said keep or store or sell or disassemble. So therefore he says, there ain't no argument that I got all kinds of cars stored and kept there because that's why the city's on my tail. The court said, point well taken. That's what the ordinance says.
So if they change the ordinance and wait another year,
I don't think it would work because he's non-conforming under the old ordinance. But I'm not sure. That's a really good question. Okay, another story about the interpretation. This is Sandy, lovely residential neighborhood. Right in the center is this picture is Steve Brown's house. Steve Brown was a very precocious person. This case was decided in 1998. Airbnb was founded in 2005. But Steve Brown and some of his buddies created a website called the Sandy Ski House website. And if you were from California and wanted to ski at Bigger Linwood Cottonwood Canyon, you could rent Steve Brown's house. And you'd bring your family, because that's the only outfit that would need a house this size, and you'd stay there and just pay Steve for a weekend's rent, and then you'd go away. Well, the neighbors don't like this. They'd wake up Sunday morning and there'd be beer cans in the gutter, and they couldn't get the teenagers out of bed for church because they were too sleepy after watching what was going on in Steve Brown's hot tub overnight. So the city said, we're shutting you down. You violate the ordinances. And Steve Brown says, how so? The Court of Appeals said, how so? And the city says, the city cited provisions of the ordinance stating that the single-family zones were designed to create a residential environment that's characterized by moderate densities, a minimum of vehicular traffic, and quiet residential neighborhoods favorable for family life. See? You can't rent your house overnight. It says right there. And Steve Brown says, no, it doesn't say that at all. I'm renting it to families. I'm just renting it for a few days instead of a month. There are other people in the neighborhood that rent their houses. I mean, yeah, they're year rentals or 2-year or 3-year rentals, but we're all just renters. We're all landlords. That's a business. Landlording is a business. And the town said, but you're running a hotel. It's short term. And he said, I'm renting it to families, and your ordinance doesn't define what I'm doing as illegal. And the Court of Appeals says that's right. So the Court of Appeals said this: because zoning ordinances are a derogation of a property owner's common law right to unrestricted use of his or her property, provisions therein restricting property usage should be strictly construed, and provisions permitting property usage should be liberally construed in favor of the property owner. So again, all this discretion to write the ordinances, but once they're written, we read them the way they're written. And the court simply said, in this case, you didn't define a dwelling in a way that prohibited short-term rentals of a dwelling. Now, Sandy then went in and created a short-term rental ordinance. Steve Brown's now a non-conforming use. Sandy bought the house. Interesting enough, another case came down this year on the same subject involving a sister city here. This is South Weber. And somebody had an Airbnb, and South Weber tried to shut her down, and they got into the ordinance again at the same Court of Appeals, and the Court of Appeals says, well, South Weber prohibits lodging, motels, and boarding houses. And what you're doing sure sounds a lot like that. So we're going to uphold the city in that case, because the ordinance in that case specifically prohibited short-term rentals. And of course, if they had a short-term rentals ordinance, no question, they would have been able to regulate it in a way that Steve Brown might not have been amused by at all. Question about that? Okay, so we interpret the ordinances the way they're written, and we do it in a manner consistent with the property owner's right to do what they're not specifically forbidden from doing. This is a case involving Springville City, and they had the unfortunate experience of being sued by an entity that called itself Springville Citizens for a Better Community. So you got Springville Citizens versus Springville. And it was all over a subdivision on the foothills. And again, we'll do this conversationally. So the Supreme Court, again, this is the Supremes talking, what's going on? And the plaintiffs, the neighbors here said, well, they created a subdivision, but they broke their own rules. And turns to the city and says, what do you mean? You broke your own rules? And the city said, we substantially complied, Your Honors. This is really nitpicky. What's going on here, Your Honors, is we put in the ordinance that if there's a canal on the property, then you need the signature of the canal company indicating that the canal is properly drawn on the plat. And Your Honors, here's a letter from the canal company saying the canal's drawn properly on the plat. And the court said, is that all? And the city said, well, there's one other thing. It said we couldn't apply conditions on a subdivision without running them through the planning commission. And we did attach 3 new conditions. It rose to 27, I think, on the approval after the planning commission recommended it, and those 3 were not reviewed by the planning commission. But you know what, Your Honors? Here's the minutes of a planning commission meeting where they approved all those conditions. This is just a total waste of time, Your Honors. And these guys are being way too nitpicky. And at this point, the court might have said, well, who wrote the ordinance? And the city would say, well, we wrote the ordinance. And the court said, well, then we're not being nitpicky. You are. You're the ones who said the plat had to be approved by the canal company. If there was a canal on the property, had to be drawn right. If you didn't want that followed, why did you put it in the ordinance? What does the word shall mean to you guys anyway? And they said the same with the conditions on the subdivision plat. I mean, you have to follow your own ordinances. So this plat was illegally approved. And then the court turns to the citizens and says, okay, so what? And the citizens say, well, they didn't follow their own rules. No, the court said, you missed the point. So what? And the citizens said, well, we're offended that they didn't follow their own rules. And the court said, how did it hurt you? And we don't want the subdivision. No, how did it hurt you that the subdivision plat didn't include the signature of the water company? It was meaningless. It was nothing. So here's our state rule. So these are the 2 rules that came out of the Springville Citizens case. Municipal authorities are bound by the terms and standards of applicable zoning ordinances and are not at liberty to make land use decisions in derogation. So we have to follow our ordinances. Second, the city's failure to pass the legality requirement does not automatically entitle the plaintiffs to the relief they request. Rather, plaintiffs must establish that they were prejudiced by the city's non-compliance with the ordinances, or in other words, how, if at all, the city's decision would have been different and what relief they're entitled to as a result. So, 2 important holdings from the Springville Citizens case. We do need to follow our own rules, but if anyone has grounds to oppose it, they have to show how they are individually damaged. It's not possible to come and challenge administrative land use decisions by claiming, some great public interest. Usually you have to really prove you're damaged personally somehow. Question about that? Okay, we're making great time here. Let me tell you another horror story. This is Salt Lake County. I know that's hard to believe because it looks like, kind of rural area with large lot homes and some beautiful landscaping. Looks like a little creek running through the center of that. And by the way, the road running through the center diagonally is 72nd South Street. This is what it looked like 2 years later. The home in the center of both pictures is the same. So a guy named Croxford lived there, and he was in his 90s, and he had some peace and quiet, and he also had 3 daughters with a ferocious sense of justice. So the daughters went to Salt Lake County and said, you can't build a shopping center around our lot. It's illegal. And the county commission said, yeah, well, we're going to do it anyway. And they told the developer, we're sorry, we can't control this property owner, we can't condemn them, or don't have a redevelopment area here. but we're going to give you whatever we can give you, and that is we'll give you half the street in front of their house. So you can build your shopping center right down the center of the two streets closest. There's the street sign, still there. So if I stepped back one step from taking this picture, I would have fallen into Walmart's trash bin. So it's Bed Bath & Beyond, Mr. Mac, Ross Dress for Less, and Walmart. And these guys now have about a, 20-foot wide street in front of their house and no cul-de-sac. So they went to court and asked the judge to stop the building of the shopping center before it got started. And the judge said, I'm not going to grant the injunction, but Hermes, you're proceeding at your own peril. So it goes to the state Supreme Court 3 times. First time to decide these guys had the right to be there. Second, to decide whether or not they were really damaged. And third, to award legal fees against the county. And the property owners won every one of these cases. And what the court basically said is, well, this is what the court said. Where the encroachment is deliberate and constitutes a willful and intentional taking of another's land, equity may require its restoration without regard for the relative inconveniences or hardships which may result from its removal. Tear the buildings down. This is a drawing from the Deseret News of how they were going to have to build a standard 50-foot wide county street, a full-blown cul-de-sac, and another thing that the Croxford daughters, one of them was named Mybos, also sued was that the county conditional use permit for the development said if you abut a public street, you have to put in 20 feet of landscaping. So they would have not only had to build a street, but put in landscaping. So based on the decisions of the Supreme Court, Ross Dress for Less was moved out of its building and they were ready to start the bulldozing. They were not torn down. The Croxford family did sell the property. I do not know how many zeros there were on that check, but I guess a very large number of zeros. But Mr. Croxford at this point had passed away, and so his daughter said, well, okay. He lived out his years in his home and it wasn't demolished before he left. But this is the best story we have of what happens when local government doesn't follow its own rules. Question? I sure know how to kill a conversation here. No. By the way, this may be the reason why Salt Lake County has a council form of government now. This was made by the old county commission, and it was changed right after this. Okay, so administrative land use decision will be upheld if it's supported by substantial evidence in the record and is otherwise legal. So it complies with the state law, complies with the federal law, complies with the ordinance itself. End of that part of the conversation. So I just have 2 things to touch on. We will be done by 8 o'clock. First, I want to talk about conditions on development. And basically a condition is when someone comes into our application and they say, okay, approve this, and we say, well, we think you need to donate land for this street and put in the curb gutter and sidewalk and bury the power lines and take care of this ditch and all this kind of stuff. So that's really common. This is the most often asked question for the current ombudsman's office. This is the area of the greatest disputes. So just want to touch on a few highlights here. Under federal law, this comes from the United States Supreme Court. This is the only place you're likely to encounter the Fifth Amendment, property rights. I mean, you encounter a lot of people claiming property rights, but the only way they have property rights is if they're vested, and then it's under state law, or if they're denied all use of their property, or if there's an illegal exaction imposed on them. That's the constitutional questions in land use almost. So there's 2 tests here. And basically it boils down to this. Do we have the authority to impose this requirement? 2, does it address some burden imposed on the community by the development? 3, is the burden imposed on the development roughly equivalent to the burden the development imposes on the community? And that's pretty much the whole ballgame. This is a beach house in Santa Barbara. By the way, I'm sorry I don't have better pictures. Maybe the ombudsman would give me a grant and I'd go out and get better pictures of Santa Barbara. Nolan's bought this little bungalow and wanted to make the beach house that they put there, and the California Coastal Commission had the authority to sign off on the building permit. So the Nolans were the 53rd family to show up and want to build something, and the California Commission told them the same thing: give us the beach. Because in California, you can see kind of where the high tide might have been if this photo was taken at high tide. That high water mark is the edge of the public domain. And above that is private land. So the property owner has the authority to restrict public access. And this irritated the California Coastal Commission. So every time somebody came in for a building permit, the Coastal Commission would say, we're only going to let you build if you give us the beach. And the United States Supreme Court said, you don't have the authority to demand that. Where does it say in your charter that your job is to gather title to beaches? We're interpreting it narrowly. It said, in fact, it got really nitpicky. The Justice Scalia, who wrote the opinion, said, I can see where you have the ability, your goal is to improve access to the beach, but not access along the beach. And we're reading this narrowly in favor of the property owner. So the court said, this is illegal because it's beyond your authority. So when you try to impose a condition on a subdivider, that condition must be authorized in your ordinance. The ordinance must treat that issue. When a person comes in for an application approval, they're not a resource to be mined. They're there to solve the problems they're creating and to comply with the ordinance. And remember the vested rights rule: if it complies with the ordinance, they're entitled to approval. Next question. This is Florence Dolan's hardware store in Tigard, Oregon. And it looked like that picture at the top. And today, on the same property as this building, when Florence came in to get her approval, Tigard said, well, Florence, you've got this creek right next to your property. You need to give us the creek. And Florence, I'm paraphrasing here, of course, Florence said, well, I've read the Nolan case, and you can't just demand the creek. And they said, no, this is different. We're solving a problem you're creating. You're going to have all kinds of stormwater off that big roof and that new asphalt, and it's going to come into the creek. So if you give us the creek, we can manage it for stormwater. And Florence said, okay, we'll talk about that, but you also want me to build a bike path? They said, yeah, along the creek, between the creek and your building, I want you to build a very nice bike path. And she said, I've been selling toilets for 20 years. Nobody took one home on a bicycle. I don't understand. And Tigard said, well, no, Florence, this is the 21st century. Actually, it was 1994. But she said, or the Tigard said, look, we have a transportation plan including all kinds of elements. We got cars and trains and buses and bikes. You know, this is our integrated transportation plan. And since you're creating more traffic on our roadways, you can help pay for a bike path. It's all part of the plan. And the Supreme Court of the United States says, okay, on both counts, as far as it goes, except it must be proportionate. So the city had a duty to show with its own math and calculations that the burdens they're imposing on Florence were fair. That the burden she's imposing on them, if you quantify it in dollars, is roughly equal to the burden they're imposing on her. So, close enough. Oh, and by the way, the court said, you can impose an easement across that canal. You don't need to it to solve the problem. It's too intrusive to demand title to the canal, the creek. So make her promise not to damage it. Make her promise to maintain it. Make her let you maintain it. But taking a deed is a very intrusive way to solve a problem. That doesn't mean subdividers don't dedicate roads for their traffic. I mean, that's very common. That's not at all what we're talking about here. Question about that? Yes.
I have a question about conditions of a development. If a developer comes in and, or a property owner asks for a rezone on their property that is not in the general plan, does the city have the right to impose conditions on that rezone?
That's a really good question. And I'd say it's a matter of degree. The main problem you have is not the Supreme Court opinion where it was an administrative decision. Because in a legislative decision, you can just say, yeah, we don't like it. You know, it's not in our vision. In fact, with that Harmon store, they actually didn't say no, never to Harmon's. They just said, we don't like this one. Bring us another one. And they weren't bound by their general plan to approve everything. They wanted Harmon's to come back with something better. Well, there are limits to the conditions that can be imposed on rezone requests simply because the state legislature has said land use decisions that impose conditions must be roughly proportionate. And they didn't distinguish between legislative and administrative. But if you're trying to impose a condition on a legislative decision, then that just better not be the reason you turn it down if they don't agree to it. There better be some other reasons, is all I'm saying. But there are, in terms of annexation, for example, there are just all kinds of more discretion there than you'd have if somebody were already zoned and already building and just came in, or already, densities approved and just comes in for subdivision. So I know this is kind of long and convoluted, but it's not limitless in the legislative arena, but it's a whole lot more flexible than otherwise there would be. Another question is, what about the idea this person comes in and they want to build out here, and our utilities are here, and they need to have utilities to serve, and all the intervening property owners would benefit from those utilities, but this guy can't build till he builds them. So we're making him put in all these utilities to get out to here, and that's disproportionate, according to the property owner. And the city's saying, we're just saying you can't fight a fire without that water. So how are you going to meet the fire code? So there's, again, a lot of flexibility when the city is trying to make sure that new development has adequate public facilities. So the developer has to show that they have adequate public facilities. And if the developer says, okay, I'll put in a water line, but these 20 homes can be served with a 4-inch water main or a 6-inch. And the city's saying, on our general utilities plan, we have an 8-inch there or a 12-line pipe. And the proper resolution there is for the city to pay for the extra sizing out of its impact fee funds. That's what it's for. So that the overage over and above what the developer is imposing and then is paid for, because there's no reason to lay 2 6-inch lines or dig it up and replace it again in 3 years. But there is some accommodation. Make some sense? It's easy to generalize about this and really hard when you get in the weeds on a specific request. That's right. You typically don't. But often, and I don't know how it is here, but most of the time what I'm used to is a person coming in with a rezone and a site plan or subdivision plat at the same time. And that's when but if a person just comes in for a rezone and wants the density, that'll be a little tricky. But in the proper kind of development agreement, you could craft a solution to that problem. Negotiate it out and craft the right solution.
So say they came in for a rezone with a plan and we rezoned it, but the rezone is not attached to that plan and now they want to change it. How can you attach a rezone to a plan?
You can in a development agreement.
So it would have to be in a development agreement if you're gonna make those.
That's the way you attach those.
That's right. And you record that in a way that you don't have to record all the details, but you put notice of the agreement on the record on the title. So, because that way, then you know future people will be bound by that. By the way, just in case you hadn't noticed, the legislature, by the way, I don't want to misinterpret this, but you probably knew already the legislature is not unaware of the needs of developers. Is that, okay. They changed the ordinances not that long ago to say a development agreement does not need to comply with the local ordinances. if the development agreement goes through the planning commission to the city council in the same way that an amendment to the ordinances would go. So if the planning commission considers a development agreement that's inconsistent with any part of the land use ordinance, density, setbacks, whatever, and reviews it and recommends approval, has a public hearing, then the city council holds a public hearing. Well, I'm not sure they even need a public hearing in the city council, but the public hearing in the state code is required at the planning commission. But then it's adopted with all the formalities of an ordinance, then that development agreement becomes a law unto itself. And there is no prohibition in state law against contract zoning or spot zoning. Those are just antiquated terms that we don't use much anymore. Anything else on that? Okay. That's right. By the way, John and Florence Dolan put this plaque in the sidewalk that I took a picture of when we were right on the way to the bike path. This is where we trumped Tigard, Oregon, at the Utah Supreme Court.
That's awesome.
Okay, so again, these are the questions. Do we have the authority to impose the condition? Does it address some burden imposed on the community by the development, and is it roughly equivalent? That's the process we go through. But remember, behind this is the basic rule. If it complies with the ordinances, it has to be approved. So if we come in with a condition and say we want this, and the developer says, but where in the ordinance does it give you the authority to impose that? My application complies with the ordinances. And you say, well, shoot, we should have had that pending ordinance up there before you filed. Yes.
So, like on this, I mean, we've used this a bit in this city is to kind of leverage developers to build infrastructure. And for, neighborhood roads, that's one thing, but to pull in for, regional or kind of citywide transit, which is above and beyond your neighborhood feeder roads. What's the approach on that? I mean, that's a condition, you're talking about, an 80-foot right of way instead of a 60-foot. That's some additional infrastructure and everything like that.
Well, since you asked, planted question. I know, isn't this great? Great minds think alike. This is 35th South in Salt Lake County, out west toward Magna. And the road's a state highway. It's a 3-lane right now, center turn lane. And there are power lines on both sides. But on the county road plan, they want this thing widened another 32 feet or so. So the guy comes in to build Westridge Meadows, and they say, no problem, widen the road. This red line indicates the amount of property that the county wanted him to dedicate to the county. And then they made him move the power lines, new curb gutter and sidewalk. And so this guy was not a really good friend of the Supreme Court. He went there 3 times. And the last time the Supreme Court said, we are never hearing another case where you are the party. Because he just wouldn't let it go. And as a developer, developers don't like this case because he pounded the court so hard they took a stand that really makes it a lot easier for cities. And they said, yes, the city has to do the analysis to show it's fair. But in this case, Salt Lake County had just adopted the ordinance saying, if you're on an arterial highway, when you build something on it, you've got to widen the highway. And they didn't put any kind of balancing test. So the court said, then the balancing test has to occur as you enforce the rule, because you can't enforce the rule if it's not proportionate. So county, you've got to do some analysis. So the county went ahead and added up all its transportation facilities and divided it by the number of houses and said, it's about $8,000 a house. That's the cost of our transportation facilities. So we can make him do 8 times his 43 lots, or about $334,000. Court said, okay, thanks. How much did it cost you, Mr. Developer? It was $180,000. The court said, you got off easy, go home. So even in the informal basis where the exactions are imposed, again, the county had an ordinance allowing the exaction. So the guy couldn't comply with the ordinances without meeting the exaction. If the county simply showed by its reasonable arithmetic, again, substantial evidence in the record, of what the burden, transportation burden is of additional house, then the county wins. And that's what happened here. So there's also room for negotiation. And if the land isn't zoned, there's more room for negotiation. It's not an exact science. But it's, there just has to be a situation where a legislative decision is not made solely on the insistence of an illegal exaction. That's when the line would be crossed. Okay, so here's an example. This is a 40-acre parcel in a southern Utah community that will remain nameless. Guy's mother lives on the property, and he goes in and he says, I want to build a second house so I can be near my mother as she ages. And the city said, well, okay, you have to divide it though. We won't let you build two houses on one parcel. He said, okay. So he goes out and gets this plat drawn up, and he divides the 40 acres into two 20-acre parcels. And the city says, good. Oh, we've redlined the plat. And the guy says, well, what's the line? And the city says, that's where all the new roads are going to go. So we want you to dedicate 33 feet of your property to us, and then sign here. He says, well, what is this? And he said, well, when your neighbor develops, we want you to build your half of the road. He said, I'm just building one house. So I'm the ombudsman. This is early in my time, and I call the city and say, what gives? And they said, well, we're just asking. I said, he says no, and they said, okay, we'll give him his permit. So that's my war story. Okay, so to summarize then, this is what the process is. An applicant completes the application and pays the fee. Then the applicant shows that it complies with the ordinances. But if it's denied, the applicant then comes to the Land Use Appeal Authority. That can be a hearing officer, as you have, or it could be the Board of Adjustment in cities that still have that vehicle. It could also be another appeals body. The appeal authority then could hear the matter and decide if the decision was made illegally or without evidence in the record, or the person could ask the appeal authority for a variance. That is not really a good way to solve the problem very often. It is necessary though, and we've done several of those here in the city where a person's property just didn't conform to the standards, and so the city recommended that I consider and grant variances, and we've done that. And that's, we try to do it quickly and efficiently so it isn't anybody's big problem. If the appeal authority's decision isn't to anyone's liking or to some person's disliking, then it can be appealed to the district court in 30 days. The critical thing are the deadlines. This is Brindle v. Draper. Brindle owned a lot here in this area, and the city of Draper said you can't build on a lot with more than 30-degree slope if you don't have the permission of the Planning Commission. And this is an older case with it's a strange provision in a code that wouldn't be written that way today. But as we go forward. So somebody came in and asked for permission to build on the lot, and the neighbors came in and clamor, and the Planning Commission said no. Then some time goes by, and Brindle comes in and says, I want to build on the lot. And the Planning Commission says, well, where's the neighbors? I'm just embellishing what I read in the case. But the Planning Commission did make a decision because there wasn't any protest from the neighbors. And I don't know whether notice failed or somebody missed a beat or whatever, but there was no opposition to it, and so they said, okay, go ahead and build your house. And I also don't know this for sure, but the deadline in Draper is kind of a short deadline, maybe 14, 15 days. So the property owner in this case didn't dig anything until that time had passed, and then goes out there with a backhoe and starts digging. And the neighbor's going, what's happening? And he says, I'm building a house. And the neighbor said, oh, no, you're not. And the city council, the neighbors stormed City Hall. The city council red tags the project and says, stop it. And Brindle said, I'm just building a house. I have permission to build it. And the city council said, but you snookered us. That's another legal term. Because you pretended like the neighbors didn't care. And he said, I don't know whether the neighbors care or not. All I know is it's been 15 days. And the Court of Appeal says, it's been 15 days. And the city said, well, we didn't know. And the court said, well, who's the planning commission affiliated with? You know, are they the Chamber of Commerce? The planning commission made a decision. The city knew or should have known of the decision. And yes, the city can appeal the decision, but only within 15 days. And the city might have said, well, why such a short time? And the court may have said, you wrote the ordinance, you set the time. So it applies to everybody. The times run past and the decision stands. So anyway, Brendel built his house. But the critical thing is people often, they'll come down to City Hall, they'll talk about things, they'll try to work things out, the deadline will pass, and then they'll reach an impasse, and they call me as the ombudsman back in the day and say, well, I want to go after him, and I'll say, I'm sorry. The time passed. They said, well, the city was working with me. I know, but the ordinance is clear. The time passed. The only way to work with the city and keep it alive is to file your appeal and then work with the city before it's resolved. But you can't miss the deadline. So these appeals are, and the reason for that is simple. In the land use arena, property owners need some predictability, you know? They need some handle on how long this is going to be up in the air. So there's a deadline to file a referendum and there's a deadline to file an appeal. If the appeal isn't filed, then the rights are solid and done and it's over. And sometimes that's a good thing because sometimes, you know, we mess up and make a decision. But if a person relies on it and the time to appeal is passed, then it's final and the world moves forward without having to redo things that shouldn't need to be redone in the first place. Sure.
I heard that Piscataway has put a moratorium on building because of water. What would you have to do in order to do that? How would you prove that you don't have enough water? I guess they have their own water company or whatever, but we get it a lot of times, so we don't have any water. You know, how in the world are you doing this when there's so little water?
Well, and I think I'm trying to remember, Hennifer, I think, has that issue too, and might be doing some delays.
That's actually the city she's talking about is Hennifer, because I do remember this.
Yeah, I hadn't heard of Manaway. But anyway, a lot of evidence in the record. I mean, you'd have to really, you're eliminating all use of somebody's land. But if you got evidence, remember we said that all bets are off if there's a compelling countervailing public interest? Then that's a compelling countervailing public interest. Because if you don't have enough water to fight a fire, if you can't support the community, then that's it. But if the city's, let's say for the city's just doing it because everyone's afraid their water table is going to drop and their wells might go dry, and the state engineer, I mean, that may be an issue for the state engineer. Somebody has a well permit and you're telling me they can't build a well because it might damage some other wells? Well, that's a state engineer function, not a land use. But if there simply is no way to provide water and the property owner has to connect to the city system because he's within a certain distance of the city system, then it's complicated, but with enough evidence, I think that kind of moratorium could hold water. Sorry for the... But it has to be deliberate and it has to have a lot of expert review. And once it's shown by evidence that the city would be severely prejudicing the rights of the people that are existing in the community and it's not just growth control, then it might stick. But that's a big enough issue right now that the Utah Land Use Institute is going to focus on its first day of our fall conference on water issues like that one. Yes.
I think water issues here would be a tough battle to say we don't have enough water because a farmer has water shares.
Yeah.
You have to turn in a water share to the culinary people to say, okay, that water, they've done figures and say every house needs this amount. And then the secondary company requires water shares. So all that has to happen before you can develop property to tie into all the services that we have here. So how do you use water as a reason you can't develop here?
Well, Pleasant View, for example, a few years ago, they didn't have a problem with enough water rights. They had a problem with enough water resources. So they had water, but they didn't have enough well capacity. So they called a timeout while they were actively working to dig a new well, and when the well came on board, they said, okay, let's go. So having the water rights is different than the resources. In fact, the argument can be made that Utah's way over allocated on water rights. But so my guess is it needs to come into a resource issue. And somebody in the valley, we own a place up there and in Ogden Valley, and the Valley News published an article, I think because the editor's running for the county commission or something like that. But the article said, why, I didn't mean to be cynical, I think this was her argument, why are we giving new well permits when we know we don't have enough water? Well, that's a different thing. A well permit's based on a resource. They're creating creating their own resource with the new well. And that new well from the aquifer is not affecting the shortage of water in Pine View Reservoir. They're kind of different things. And I don't think I am as smart as I just pretended to be, and certainly not smart enough to run for the county commission. So anyway, just to illustrate the point. Another question or comment? Hey, you've almost endured this whole thing here. Variances are only granted in limited circumstances. These are the rules. And the person who wants a variance must prove they have a substantial property right at risk and a hardship that is undue, and that it comes from the property itself and not their preferences. And I won't get into this much because it really hardly ever applies much, except for you have casual conversations often with people in the community, and they're saying, what would we do? And they might say, well, the law doesn't allow me to do this. Do not suggest to them they get a variance. Because they'll come to me and I'll say, I'm sorry, but you don't have a protected property right in building a garage or dividing your land. I mean, you have full use of your property, and yes, it's 198 feet long and the minimum width of a new lot is 100 feet. But you're not entitled to divide your land if it doesn't comply. It's not a substantial property right. It's not an ordinate hardship. And nothing changed, by the way. That's how it was when you bought it. And granted, it's an economic benefit to have that. But if you want the lot width to be 98 feet, I know who can do it. The city council, not the hearing officer. Because my job as your hearing officer is interpret your rules, not to impose my preferences on local policy as a guy from out of town who wasn't elected by anybody. Yes.
One of the things I think one of the things that I've seen in my career handling stuff and dealing with variances is that people will want a variance just because, or they created a situation that they want to get a variance to get out of. And one of the things that's not one of those main 5 points, but state law talks about with hardship, is that it can't be economic or self-imposed.
Right.
Like, they can't get a variance, they can't say, well, I can't afford to comply with the rules, so I need a variance. Well, that's not a reason. And they can't get a variance because it's like, well, I really just need to have this 3 extra feet into the side yard setback so I can fit my boat in there, because I bought this boat, I need to put it into a garage. Well, no, you don't.
Yeah.
They can't get a variance for a situation that they create.
Yep. It's a pretty precise instrument and can't be used as a blunt instrument to solve a problem, really. And I feel bad. One of the reasons I try to hold hearings really quickly for the cities like West Haven is to get people on the right track if I'm not the right track. And the staff's been great to work with. We had a case recently where we just did a course correction. Within over a weekend, we held a hearing, and then the guy what we found actually was the ordinance he thought needed to be changed, if you interpreted it the way the city interpreted it, didn't prohibit what he wanted to do anyway. So that's, it's whatever works is good. Okay, well, we can call it there. Any other questions or comments? Any other things you want to just chat about while we're all here? We've got all the land use decision makers in this room. Yes.
We actually have a situation that, was noticed within the last few months where we have hundreds of homes built in a zone that doesn't actually exist, or it exists, but it doesn't exist for residential use, an open space zone. It's something that our staff is working to resolve.
Mhm.
That's obviously an issue. But we've had, I guess we've had conditional use permits come in and, building permits for shops come in for homes in this zone where an ordinance doesn't exist for residential use. I mean, how should the city be looking at that? How should we be reacting to that?
Well, and it's, I'm sure, more complicated than a simple answer would give. But
Probably.
if the city took any action to allow a construction, then the time has passed for the appeal and the decision's final. And part of that's what we call zoning estoppel. And that just means if an official issues a permit, even though it might be wrong, once the person's relied on the permit and started digging, then the city can't come in later and try to, the city is estopped, the legal term, from coming in and later and trying to enforce the rule that was ignored, even innocently or in good faith. Or the essential thing is just the mistake was not the property owner's mistake. And if they relied in good faith and have clean hands, then they can't be made to undo the mistake.
Well, that's not the issue. We, as far as I know, haven't had any city staff try to stop something that's already been permitted for one, homeowner, one resident, but in the past, these things were permitted, and then now, because we have such great staff, they've noticed the issue and have stopped permitting, buildings and things like that until we can resolve the issue. But where, I guess my question is really more of, if the ordinance doesn't exist to prevent it, how can we necessarily say no to it? Does that make sense?
Yeah, well, if the ordinance doesn't prohibit it, then it's consistent with the ordinances and you can't say no. But if it's not consistent with the ordinance and the ordinance on its face does prohibit it, and there is some wiggle room here for lawyers, for property owners that say, well, they've interpreted the ordinance, this language is loose enough that this might be legal, and that's how they've always interpreted it. And in that kind of a situation, the property owner wins. But if the property owners were clearly allowed to do things that were inconsistent with the ordinances, and on its face the ordinance doesn't allow it, then there's no duty for the city to keep doing it. You know, again, painting it with just a broad brush. But one of the things that is not really a good practice is to have a lot of nonconformities. So if the public policy is just to, you know, if this is what's here, let's allow it, then one thing you consider is just allowing it, you know. Ogden, for example, took the whole east bench and made it like a minimum 10,000 lot size. And there's all these houses on 8,000 square foot lots. What is the purpose of that? You know, nobody's subdividing in the foothills of Ogden. So they made all these buildings non-conforming. And they may have changed it since then, and maybe I'm just, you know, talking about something that isn't even a problem anymore. But it'd be great if we tried to make life legal. But the problem is I'm just spouting off on things that may be highly emotional, and I have no idea what I'm talking about.
So to follow up to that, if you discover that the ordinance specifically prohibits it, and then you stop allowing it, but it has been allowed in the past, you haven't set a precedent with because you've allowed other landowners.
Not necessarily, unless if the precedent's set by subjective review, you know, subjective conclusions. For example, one of the cases I didn't show because of time was a group home in Duchesne. And the county turned down this group home, but the Court of Appeal said, but you approved one right over here and you turned this one down here, and you never defined the difference because of subjective issues of whether it was compatible and all that kind of stuff. But that's different than the hard and fast rules of the evidence, the ordinance, I mean.
This is more of a situation where it prohibits it and it was allowed mistakenly over a long period of time.
Well, the best solution's bound to be a political one, but if I was the lawyer trying to force another house, I think I'd struggle trying to force another house if it's clearly not allowed in the ordinance. And all that, I'd have to show that somehow I had been personally prejudiced by this not being done in a way that I should have, that I was something I was legally entitled to. I was not legally entitled to it if the ordinance prohibits it.
We're just trying to clean up a mess.
Yeah. Well, hats off. That's why you guys get all the glory you get. At all the, the community accolades, and not to mention the incredible salaries you're paid.
Sherry deserves a bonus.
That's right. I guess. I hope you would. And guys like me, I don't have to handle that tough stuff. The policy questions are the tough ones. And hats off. So.
Well, you might not think that in that much time when public clamor is out there, so.
Well, that's true.
See how it goes. 811.
Yep,
803, I think.
815,
Oh, 15.
yeah.
Well, the good news is you stumped the dummy, so I don't know for sure. I've gone a minute over, and I don't mean to do it. So,
Sorry, I have one more question.
sure.
To drag some, but just for clarification on interpretation of ordinances, so if there's any ambiguity in the ordinance, it'll typically go to the favor of the property owner.
If it's legitimate ambiguity, then we interpret in favor of the use of land. But one of the things that matters is how the city's interpreted it in the past. That's a factor. And the fact is, I can spout some general rule, and the right kind of attorney, coming in the way she does it, can easily win a judge over and say that's how we're doing it here. This is local government discretion. And so ambiguities are no fun, and the best thing to do, of course, is clear them up by writing them.
I was going to say, anything written by an attorney becomes ambiguous for a layman.
Right, absolutely. No, I'm with you. Yeah, that's why one of the crazy things in the state statute is they'll take a perfectly logical word phrase and put a definition to it that really narrows it so much it makes no sense at all in a given context. And then you'll read the ordinance and say, okay, well, you can't build a dwelling. And then you look at the ordinance, and if you aren't checking the definitions of what a dwelling is, then all of a sudden we find out what we didn't really think of as a dwelling is a dwelling, and what we didn't think of, or we did think of a dwelling, isn't a dwelling at all. And you're right. Point well taken.
Amy missed it. Amy missed it.
Thank you so much for your attention. It's been a pleasure to be here. You bet.
Need a motion to adjourn.
I make a motion to adjourn. I second.
I have a motion second to adjourn. All those in favor?
Aye.
Aye. Any opposed? Hey, we're adjourned.
If you're opposed, you can hang out.
And like I said, if you don't have a copy of the book, you're on the staff or something, I'm happy to give you one.
I like how you wrote it.
Oh, thanks.
It flows good. It's easy
It's
to
very
read.
easy to read.
Well, it's meant to be read, not just typed.